It's exceedingly rare that a legal innovation changes the entire landscape of a field of commercial activity almost overnight. But the creation explored here, the shareholder rights plan, better known as the poison pill, is one of those game-changing innovations. It's no exaggeration to say that it redefined how corporate mergers and acquisitions take place. And it's widely acknowledged to be the creation of just one person, Martin Lipton, of the New York law firm of Wachtell, Lipton, Rosen and Katz, and as the survivor of a battle of corporate legal titans, pitting Mr. Lipton against Joe Flom of Skadden, Arps, Slate, Marr and Flom. Before we get into what the shareholder rights plan is, how it was created, and how it survived its famous judicial scrutiny in the household case, let's hear from Mr. Lipton himself about the tempestuous and uncertain setting in which the shareholder rights plan emerged.
We became very active in the takeover practice in '74, and it expanded in '75 and '76. And sort of just as chance would have it, we ended up basically defending and not attacking. And it was necessary in advising boards of directors as to defending against a hostile takeover, to answer the question whether they had the right to defend, what were the standards, what did they have to do in order to sustain from legal attack a vigorous defense. It has to be kept in mind that at that period, the hostile takeover was a 10-day affair. Under the Williams Act, it was all over in 10 days unless the target obtained a temporary restraining order, preliminary injunction, or the target found a white knight who was going to pay more. There was no time. It was pretty much a panic from the very beginning. Virtually no company was prepared for this.
Hostile takeovers were no mere abstract transactions in dollars and cents. They had vast social and personal consequences.
You know, you don't really focus on a legal issue that you deal with, whether it's a tender offer, a proxy fight, or even a contract, and so on, until you get to see what happens to the people who are affected by it. And as we defended more and more companies, and in those days, you know, you would fly out to Wichita or Kansas City, wherever it was, and essentially, for a few days, you would set up in the office of the target, and everybody there, the secretaries that you worked with, the accountants, the people in the legal department, the CEO and the executive vice president, sooner or later, what's going to happen? How is, and clearly, people were hugely affected, initially psychologically, and then the realization of the impact on them and their families and on the community.
It was clear to Mr. Lipton, and to everyone else at the time, that corporate boards of directors had very little time to respond to these enormously important transactions. In just 20 business days, a bidder could buy enough shares from the thousands of a company's stockholders to take immediate control of the company. And it was clear to Mr. Lipton that stockholders wouldn't stand in the way of that change.
By 1982, even though the SEC regulations had been changed so that you had the 10-day period had been extended to basically call it 30 days, 20 business days. You still had an almost impossible problem in getting the time necessary to effectively deal with a hostile takeover bid. And it was also, we had an experience with a company called St. Joe Minerals, where we tried to get, it was controlled by 12 institutional investors. They had 50% of the stock among them. And the bankers in the company thought that the bid, it had been a hostile bid by the Seagrams Corporation, thought that the bid, even with the premium, was less than half of what the company was worth. So we thought that we could go to the 12 shareholders and get an agreement that we would amend the charter to liquidate the company if within 18 months the stock was not selling at a higher price than the Seagram bid. Not one of the shareholders would agree to that. So it was clear that litigation was the only way you could stop either litigation or a higher bid.
Well, not quite. In addition to the litigation, boards of directors took some other, more dramatic approaches to resisting takeover bids, including selling or optioning off crown jewel corporate assets, offering to buy back the corporation's own shares at a premium to market, or even, in the notable Bendix bid for Martin Marietta, making a bid to buy the bidder, a turnaround described as the Pac-Man defense. Unfortunately, these defensive measures imposed enormous costs on the company, even as they deterred takeovers by making the company less attractive to a bidder. So some boards took a different tack. Using their power to issue stock, and at no cost to the company, some boards distributed shares of newly created preferred stock, whose sole distinguishing feature was the right to vote on any second-step merger with a bidder who had acquired a large block of stock. To complete an acquisition of 100% of such a company, a bidder would have to get the approval of over, say, 80% of the stock, a high hurdle for a bidder to overcome. But would a defensive stock issuance like this pass muster in court? A case in 1979 suggested not. In Telvest Incorporated versus Olson, Vice Chancellor Grover Brown of the Delaware Court of Chancery preliminarily enjoined the distribution of Telvest's first series preferred stock. He even said there is some question as to whether the first series preferred is really preferred stock, and that its preferred status seems illusory at best. On top of that, Vice Chancellor Brown also concluded that even if the stock issuance were technically proper, its imposition of new strictures on existing shareholder voting power would fall within the type of conduct deplored as inequitable in earlier case law. Well, that sure put the brakes on using preferred stock issued by unilateral board action as a takeover defense. Put the brakes on at least until 3 years later, in 1982, when Marty Lipton came up with what he described as a warrant dividend plan, a plan in which the board of directors would distribute to the stockholders by dividend warrants to buy the bidder company's stock at a deeply discounted price if and when a bidder that had bought a large block of target company stock, in a tender offer, for example, acquired the remaining stock of the target through a merger. The result? The bidder's financial interest would suffer drastic dilution. But wait, you say, how could a target company's board give out rights to buy the stock of a different company, the bidder? The answer reveals the genesis of the modern-day poison pill, as its creator explains.
So it was clear that litigation was the the only way you could stop either litigation or a higher bid. So struggling to come up with something that a board of directors could do sua sponte and get time. And I was reading an indenture for a convertible issue, and I just kind of like stumbled over the non-destruction clause. Just about every convertible and warrant has a non-destruction clause so that the option value of the instrument is not lost if the company merges with another company, that the security flips over to the surviving corporation and gets adjusted for the price of the merger, and it preserves the option value of the security. And I just said, well, why couldn't we issue warrants that flip over but at a huge advantage to the shareholders and create huge dilution if the company is acquired and then it's merged. And as most of these deals were at the time. And we figured out a formula and so on. And in September of 1982, I sent a memo out called the Warren Dividend Plan.
But warrant dividend plan, I looked through some of your old memos, and I saw that, and I'm thinking, warrant dividend plan, how did this become the rights plan? Is there a story behind that?
There's a story, and it involves Dick Grasso, who later became president of the New York Stock Exchange. He was then the number 2 person in the Department of Stock List, but he was basically the last word on these things, and we needed to get the stock exchange to list the warrant so that it could trade with the common stock. And the stock exchange rules then did not accommodate a 10-year warrant. In any event, he said no, and I said, well, I just don't get it. You allow the listing of rights to trade with the stock when a company is doing a preemptive rights offering and so on. A grant, they're generally short term, but there's no rule about the term. And he said, well, if you call it rights, I have no problem. So it became the shareholder rights.
But even with the new name and the blessing of the stock exchange, Dr. Lipton's marvelous new medication needed several seals of approval before boards would embrace it. One of those seals was a Delaware lawyer's opinion that the device was valid under Delaware law. Apparently, that approval wasn't easy to come by. Some Delaware lawyers thought the device was simply off-limits, like the illusory preferred stock in the Telvest case. Here's what Rod Ward of Skadden Arp's Delaware office thought.
I always thought this was a terrible gimmick. So I thought that the major issue in the case, and I thought that right down through the end, was whether this was a dividend, whether it was a right, whether it was a preferred stock,
Right.
or whether it was just a Rube Goldberg contraption to transfer the control of negotiations from the stockholders to the board.
Rod Ward wasn't the only experienced lawyer with doubts about Mr. Lipton's novel creation. As Mr. Lipton explained it,
we frequently got reaction that that's crazy, or our lawyers think that. Remember, we're kind of brought in on these situations, so the regular law firm of the general counsel had doubts, and you either are successful in convincing them that it's something that it at least has a reasonable, it's not unreasonable, not flying in the face of a legal decision that it's not legal and that it was worthwhile.
In any event, Marty Lipton persisted and eventually found support first from Lou Black and his colleagues at Morris Nichols Arston Tunnel in Wilmington.
I assume you were walking around talking to some other people, maybe even some Delaware lawyers, and trying to get their reaction as to whether this thing would actually be upheld.
Well, there's a lawyer sitting here right now named Gil Sparks. Gil and actually, I first went to Lou Black. Lou and Gil and I had been working on various things over a period of time, and we were working on something at this time. And as Gil tells it, he approved it standing in his kitchen. In any event, no one else would give an opinion. We had given opinions, and a lot of law firms said they didn't think it was valid. Legal, but Morris Nichols did.
And with that, Marty Lipton and his firm squarely put their stake down on the legal viability of the shareholder rights plan.
There's one memo, this is June 20th, 1983, and I was struck by it. It talks about the warrant dividend plan, and then there's this line: "We have no doubts about the legality of the plan." I don't see too many law firms writing stuff like that. Did this become a bet the law firm issue for you?
Yeah, you can't advise people to do something like this without taking a firm position that it's not a should position. You can't hedge. It's just, if you aren't comfortable to give a firm opinion without a hedge, you shouldn't do it. Not in something like this. And we convinced ourselves that this was legal, and we thought that we were giving opinions. We were giving unqualified opinions at that point.
Obviously, Wachtell Lipton was giving opinions, including to Household and to a couple of other companies that had adopted the pill. By the way, at this point, only a handful of companies had done so. The unease about this thing was palpable.
Uneasy because opinions from a law firm are one thing and opinions from a court are another. No court had yet blessed Mr. Lipton's creation, and his main rival, Joe Flom of Skadden Arps, was dead set against it.
Joe was against the pill from the beginning, long before Household, and he, when Household came along, he was determined to get a decision denying the legality, and I thought he went to some extremes in doing it. There's a young fellow who summered with us in, I guess, 84, who wrote a note in the Harvard Law Review arguing the validity of, and Joe claimed that this had all been a setup and whatnot. And it became unpleasant. I don't want to go into great detail on it. It became unpleasant.
That unpleasantness came to a head when the board of directors of Household International Incorporated, a large consumer finance company headed by CEO Donald Clark, took the bold step of being one of the first to adopt Marty Lipton's shareholder rights plan.
Tell us maybe what we can't see in the opinions about the thinking that went in the boardroom about adopting the pill.
There's an interesting story.
I was hoping you might say
The
that.
adoption of the pill. this is July of 1984, the call was put through from the office, and I took the call, and voice came on the phone. My name is Donald Clark. I'm the chairman of Household International Corporation. I hear you have something called a poison pill, and I think I need one. And that led to working with Goldman Sachs to fashion a presentation to the household board to have them approve a poison pill. And I was working with a partner of Goldman Sachs who just happened to be 6'6", 6'7". And we went to the meeting in Chicago. Their headquarters were in Chicago. And there were two directors of note on the board. One was Mr. Moran, who was the raider, and the other was John Whitehead, the co-senior partner of Goldman Sachs. And the Goldman Sachs partner presented deck with the typical 25 pages of analysis and so on, values and so on. And I presented the pill and how it worked and so on. And then Mr. Clark asked for board comments, and Mr. Moran was first and argued against it, so on. And then Mr. Whitehead was next. And Mr. Whitehead said, well, I don't think we should do this. I don't think a company like Household should adopt something that could deprive shareholders of a premium. The 6'6" partner suddenly became 4'4", and there were two votes against the pill, Moran and Whitehead.
What motivated this dissenter, John Moran, and his investment firm, Dyson Kistner Moran, to bring suit against the household rights plan?
Your client was John Moran. He had made some indications that he was interested in taking over Household, but it wasn't clear, at least from the opinion, that he had a very well-developed strategy to take over the company. What was motivating him? What was motivating the challenge of the pill? I mean,
he'd like to take over the company.
Was it much more? Were his thought process much more advanced? I mean, it seems from the face of the opinion that he's he had a couple of back channel discussions. Maybe thought the stock was undervalued. You got a company that has 3 lines of business, none of which really matched up. You got rental cars, financial services, and groceries. And he thought maybe separating them, busting them up could deliver more value ultimately. But he's still 5%, $2 billion company.
Dyson Kistner Moran was a leveraged buyout house, one of the earliest. And John invested in companies and looked at companies as the CEO of DKM with the view that he might like to own them and make a profit from doing that. So this was not an abstract exercise. I don't think.
Now was it? And that's what I wanted to get is not an abstract exercise. Was he looking at this in terms of if Household can pull this off, this might be an impediment not only in this particular case, but moving forward?
Well, there were 2 motivating factors. One was Moran's. His business was LBOs, and poison pills could be an impediment to that. And the other was Joe Flom, who saw this creation by his friend and arch rival, Marty Lipton, and didn't want it to survive.
Michael Schwartz of Wachtell Lipton, who represented Household in the rights plan litigation, told a similar story about Mr. Moran.
Well, Moran, first of all, was a very, very good guy, nice man, very smart man. I might add that much later, in a totally different context, he became a Wachtell-Lipton client for a while, and I was personally very fond of him. But Moran was a director of household because a company that he controlled was acquired by Household for Wallace, what was it called? Wallace Murray, for a preferred stock. And he wound up being Household's largest stockholder. He was a principal in a firm called Dyson Kistner Moran, and they were sort of an investment company. They had interests in lots of different companies, and they profited by buying and selling companies. It turned out that, and we put this into evidence, that Moran had actually proposed to Don Clark, the chairman of Household, that he and Clark lead a so-called management LBO of Household. And as Don testified at trial, John said to him, we could make a bundle of money, which Moran estimated at $415 million, by buying the company, selling off the finance business, and as Moran apparently said to Don, we'd own the rest of it for free. I cannot believe that that evidence was helpful to Skadden's case. So I would have to say that the decision to use Moran as a plaintiff probably hurt them.
The other dissenter, John Whitehead of Goldman Sachs, had different reasons for voting no and didn't join the suit against the Wrights plan.
Mr. Whitehead was one of, in addition to Mr. Moran, who voted against the adoption of the pill, saying he didn't want, I don't think he was philosophically opposed to it, but he said he didn't want the company to be a guinea pig.
Yeah.
How much fun did you have with that, given that his partners were evidently advising that this was a structure you could use, and he was throwing up the caution flag?
Well, I'll give you another piece of it you may not know. His partner, Bob Rubin, was in Washington lobbying against the pill as head of the arbitrage department of Goldman Sachs.
Right,
As I was down there with him. My father actually talked to me before I cross-examined John Whitehead, and he said, "You are be very respectful, very polite, and he's a very important fellow. The court will not like it if you try to touch him up." And was it that time, was John's daughter working for us? I think she was.
Anne
his
was.
daughter was also an associate at Skadden.
Right.
So there were a lot of
touches.
No, but you followed your father's advice,
and so-
rightfully so, because
Yeah.
he was such an impressive person.
Yeah, there was nothing you could do with John,
Right.
except, yes, he voted against it, but he thought, it was not right. He didn't want the company, which was, in a quiet mode, to all of a sudden become part of some big brouhaha.
But the brouhaha came anyway, and came quickly, in the form of litigation of the Court of Chancery.
I think Skadden brought suit. It was almost as if they had something ready. They brought suit within a matter of days after the Household Board adopted I'll call it the pill, because that's the conventional term for it. Though my recollection is that throughout the litigation, we used its proper name, which is the Shareholder Rights Plan. Skadden was, I would have to say, institutionally determined to kill this thing. And they might well have been advised to wait for another context to litigate in a situation where there was actually somebody's money on the table and the pill was being used to prevent the money from getting to shareholders. They did not choose to go at it that way. In their view, and this is the way they tried the case, this device, let's call it, was sinful. It was illegal under Delaware law, not authorized by the Delaware corporate statute. It infringed the rights of shareholders. It arrogated power to the board of directors. It was, as I said before, all things bad, including fattening.
Sinful or not, the lawyers in the case all recognized how significant the case was, both to their firms and to corporate law.
It was obviously, from the get-go, an extremely consequential case, not only in terms of Delaware law and the takeover environment, but for Wachtell-Lipton. This was the pill, the poison pill, as it was promptly named, I think by the fellows over at Skadden, who were our adversaries in the matter, was an enormously controversial development. and was much derided. The very name, poison pill, implies a sort of a sneering, contemptuous dismissal of this thing as being beyond the pale. And there was a sense, I think, legitimately, that maybe somehow or other Wachtell Lipton had just gone too far, and this was going to be invalidated. And to say that that would have put egg on our face would be an understatement. I mean, it was. I think I remember seeing an interview that Marty did some years ago, in which he thought this was, from his perspective, a bet the firm issue. I don't think he was wrong. I think if one tries to imagine an alternative universe in which the pill had been held illegal by the Delaware courts, one wonders exactly what the future of Wachtell Lipton would have been. So it was a hugely important case, and we treated it as such.
Charles Richards, Wachtell Lipton's co-counsel, whose firm had given a legal opinion to the household board that the rights plan was valid, had a similar view.
I think the general feeling among the Delaware bar, outside of us, before the argument was that it was a 50-50 shot. Mm-hmm. You'd had Joe Flom had written an article in the Harvard Law Review saying this was absolutely illegal, and of course Marty Lipton put down his stake that this was, absolutely necessary, or else Delaware corporations would be swept away by acquirers.
Stuart Shapiro of Skadden Arps put it even more succinctly.
This was a crusade against the pill, and frankly, driven in major part by Joe Flom's desire to have the pill thrown out as an improper device.
As we'll hear from the lawyers who litigated the case, the motivation to ban the pill influenced the way the challengers' various legal theories were emphasized or de-emphasized. One of those theories was that Household's directors didn't act with sufficient care when they adopted the shareholder rights plan.
We, I think, had a better than 50% chance of winning the case on the grounds of due care. The directors had no clue what the pill did. And in the depositions, we established that by simply asking them about the pill, and they just had no idea.
Even Household's Delaware lawyer acknowledged that the quality of the directors' deliberations was a potential source of vulnerability.
Now the rights plans are so familiar to lawyers and investment bankers and even maybe business people that it doesn't seem complicated. But I can tell you when those depositions were taken, it seemed very, very complicated, and Rod Ward, among others, I think, did a very good job of trying to tangle the directors up in terms of their understanding. Mm-hmm. And I thought that the plaintiffs could have done a more forceful job in the litigation in trying to pound away at did the directors really understand what they were doing.
So why didn't the plaintiff more aggressively push a lack of care as the basis for invalidating the rights plan? For one thing, Household had a truly blue ribbon board, as Skadden partners Mike Mitchell and Stuart Shapiro saw it.
The problem we had was that their board was very good. You had John Whitehead, head of Goldman Sachs, coming up through the ranks. Incredible World War II record.
Son of a lineman for the power company.
Right. Later Assistant Secretary of the Treasury. You had Ray Trube, a friend of both of ours, was on at least a dozen boards. Had seen
Supreme
everything.
Court law clerk.
Right. You had Ray Tower, who had been on the marathon board during the whole mobile marathon situation, and emphasized how chaotic that situation was and how you had to quickly do an asset lockup on one of their biggest subsidiaries, and how instead the pill gave you this flexibility to sit back and deal with a bidder and try and work out the best possible thing for shareholders. Now, maybe they didn't know all the ramifications of the pill. I give you that. But Lipton set it up so that they were certainly informed, number one. And number two, it was very hard to argue that these people were being disloyal. Even Moran testified that he thought Whitehead was an honest guy.
But there may have been an even more powerful reason for de-emphasizing lack of care as a basis for the challenge, a reason having to do with what was at stake beyond this one case.
The directors had no clue what the pill did. And in the depositions, we established that by simply asking them about the pill, and they just had no idea. So we could have gone in and won the case, potentially on that ground, but then they would have just gone back and informed the board better and adopted the pill again. So this was not about winning this case. It was about beating the pill. And so things that were short of an absolute bar on the pill really weren't viable options.
A different theory, which might have had the more comprehensive result that Skadden sought, was that federal takeover law preempted any Delaware statute that permitted rights plans to exist. But that argument didn't generate much enthusiasm, even within Skadden.
The second prong of your argument was federal preemption.
Yeah, but I never believed anybody'd buy that.
What some of the Skadden lawyers thought would carry the day for them was the idea that Delaware's corporate statutes simply didn't authorize these shareholder rights, which had no immediate financing use for the company. Rod Ward described this point through a hypothetical cross-examination.
I thought it might illustrate to you and to anybody who watches this what I thought about it. What is the right for? Answer: to buy 1/100th of a $10,000 preferred stock. What's the preferred for? You get up to $170 in dividend per share. That's a 1.9% return. Question. It's now 1985. Is the average return on such preferred shares $750 or higher? Yes. Question. Then who will buy this preferred? No one. That's the point. Would that leave the right unexercised? Answer: yes. What can you do with the unexercised right? I'm asking these questions. If somebody makes a 30% offer to household or buys 20% of household, the right holder can buy $200 worth of household stock or that of its successor for $100. Question. But that would enormously dilute the offerer's household stock if it or he bought any. Yes, that's the point. So the offerer would have to get the household board to redeem the right before it made such an offer. Yes, that's the point. So the right would never be exercised and the preferred would never be bought. You're right, Mr. Ward. Question. I never heard of such a right or such a preferred. Answer. There never has been. It's a new concept. Question. And the sole purpose of these so-called securities is to shift control over tender offers from shareholders to the board. Answer: yes. I think that's the end of the case. Well, I think the strongest argument is the one which I just went through. Strangely, I had a little deja vu as I was reading over this stuff, and it amazed me how much dither there was over the business judgment rule, which I think, if you take this thing as a legal thing, if it's adopted by an informed board, the business judgment rule certainly applies. My view is the business judgment rule has no business in supporting something like this. It's not an independent source of power.
On the other side of the V, the lawyers for household weren't as impressed with this claim of lack of statutory authorization.
Let me go back a step. In some sense, a trial is a trial, okay? And whether it's a judge or a jury or whatever, I do think you want to tell a story. And Skadden didn't have a story to tell, basically. They simply had this philosophic and academic argument. This thing is illegal. I mean, there was a technical legal argument I should perhaps mention, and that is there's a statute in Delaware which authorizes the issuance of rights, which is what the pill involved, the issuance of rights. And they had a technical legal argument that the rights had to be issued to accomplish a financing purpose. And they did make a big argument to that effect. That like any other security of a company, it's an economic instrument and it has to have a financing purpose. And this was, they called it a sham security because it didn't have a financing purpose. And we argued, the statute doesn't say anything about financing purpose. That's your gloss on the statute.
And even within Skadden, there was some doubt that the statutory argument, even if successful, would accomplish Joe Flom's overall goal of eradicating the pill.
You're right. One of the principal arguments was that the pill was essentially involved a sham security because it would never become exercisable, and therefore, Section 157 didn't authorize it. That I don't think was enough for Joe, because you could always figure out a way to find another statute.
Mm-hmm.
What Joe wanted was essentially a ruling that it was a matter of business judgment that you could not adopt a pill given the consequences of the pill becoming exercisable.
Skadden relied on one other argument that might have achieved that sort of broad ruling. That argument focused on the impact of the rights plan on the stockholders' ability to vote incumbent directors out of office via a proxy contest. Even the Wachtell-Lipton lawyers acknowledged the potential force of this argument.
The argument was made that whatever the rights and wrongs about tender offers are concerned, to the extent the pill made it a triggering event that somebody waged a proxy fight, you were impinging on the voting rights of shareholders, and voting rights are sacred.
At least one of the Skadden lawyers agreed that the impact on voting rights was a stronger horse to ride.
We had to find some statutory basis, something in the Delaware law that simply said this is wrong. I think we actually found something, which we haven't talked about yet, which is interference with proxy suffrage. Because if you read Justice Walsh's opinion, he in effect finds that the pill interferes with proxy suffrage, but then concludes by saying, but given the protecting the corporation, it's okay to take voting rights away from shareholders. That seems so inconsistent with Delaware law that I actually thought we had a shot, which shows my naivete. I think we had a shot of the Supreme Court saying you can't do that to the voting rights. Because, but the other stuff, whether it violated 157, whether it was a sham, none of that had any sex appeal.
Even so, it's not clear that Skadden even wholeheartedly pressed the voting rights claim.
An odd thing about the case was that neither in its complaint nor in its evidence did Skadden actually push this voting rights contention. The complaint didn't mention voting rights, and they didn't put on a witness as we did. We put on a guy from Georgeson & Company, a big proxy soliciting firm. They didn't. I always thought, frankly, that they missed a bet there. I mean, now, of course, the answer may be they tried to get a proxy expert and nobody would accept the job. However, they did certainly argue the point. And all I'm saying is here again, I think you see where trial strategy, could well have made a big difference to the outcome if they decide to make this a case about voting rights, not about tender offers. But that wasn't their state of mind. Their state of mind was shareholders have a right to get a tender offer. Tender offers are good for the economy. This, I might say, was a philosophical position being pushed very heavily, not only by Professor so-and-so and so-and-so, but by the SEC in these years. And the SEC's chief economist, a guy named Greg Jarrell, who, by the way, also went on to become an academic in the aftermath of serving at the SEC, had authored a study at the SEC about how terrific tender offers were and so on. So their mindset was on tender offers.
Wachtell-Lipton's Michael Schwartz sharply contrasted this mindset with the defendant's approach to the trial before then Vice Chancellor Joseph Walsh.
Skadden and we approached the trial totally different ways. They basically presented a case exclusively through the testimony of expert witnesses, and very heavily weighted in the direction of academic expert witnesses. Their principal trial witnesses were Michael Jensen, a very well-known professor, and Michael Bradley, somewhat less well-known, but also a very highly thought-of corporate finance professor. And those were the two principal people they presented. They also presented Alan Greenberg, Ace Greenberg as he was known, who was the head of Bear Stearns, and a banker from Morgan Stanley named Clark Abbott. But there's no question that the essential guts of their case was the academic testimony that this device was illegal, and not only illegal, but worked a fundamental structural change in the nature of the corporation, such that if it were to happen at all, it could only happen by a stockholder vote and was beyond the power of a board of directors to implement. We, on the other hand, approached this like a trial, not like a theoretical matter. We told a story, and the story was there's a takeover environment, there's a context in which this device was developed. The takeover environment was a very, very rough and ready business, and target companies were under enormous pressure and with very few defensive resources at their command. And we made the point by testimony from very experienced, practical world people that something like the pill was not only perfectly consistent with what was actually going on in the world, but was actually a lot milder and a lot less disruptive and a lot less destructive than what companies were doing to defend against takeovers. So they had professor this and professor that. We didn't have any PhDs from the witness chair. We had Jay Higgins, who was the head of M&A at Salomon Brothers. I think he was actually an amateur boxer as a young man. He was a street fighter, and a very, you could just tell the guy knew what he was talking about because he had actually, been in the ring and fought. We had Ray Trobe, who was a former partner at Lazard Frere, and who then went on to make a career as a outside director of a lot of different companies, and who had, again, also been actually in the ring where takeover activity had affected. We had Gordon McMahon, who was a Goldman Sachs partner. We had John Wilcox, who ran the proxy mechanism at
Georgeson?
Georgeson, right. And then we put on a bunch of our directors, household directors, notably Don Clark. He was the chairman of only the second company, big company, to have adopted the pill, and he knew he was taking a risk. But he was just a great client and also a very good witness. Anyway, we told this story about these surprise takeovers, these so-called two-tier takeovers, where a company would offer for 51% of the shares, and it would try to coerce stockholders to tender into that 51% offer by being either vague or even punitive about what the 49% that was left after the offer closed would receive for their shares. And the story we told was this. Initially, when the takeover craze began in the late 70s, companies were really at a loss. They didn't know what to do. But pretty rapidly, and Higgins was very articulate about all this, pretty rapidly, companies developed all sorts of ways of defending against takeovers. For example, but they were many of them were quite radical. For example, when Bendix went after Martin Marietta, Bendix bought Martin Marietta, but Martin Marietta made what was called a Pac-Man tender offer for Bendix, and wound up with a crazy corporate structure with debt equity ratios that made no sense, and the company was a sort of mess when the process was over. You had Marshall Field Company went out and bought companies it wouldn't otherwise have bought to create an antitrust obstacle against an acquirer. So it made an uneconomic decision to spend a lot of shareholder money, essentially to fend off a takeover. Carter Hawley, another company, engaged in a self-tender, which again changed the whole stock structure of the company in an effort to defeat a takeover. Unical, the case which wound up in the Supreme Court just before our case, in the Supreme Court of Delaware, that is, made an exchange offer of its own shares, but it excluded from the exchange offer Boone Pickens' company, Mesa. Okay, the point we made in our evidence, and we argued it then in the Supreme Court of Delaware, was these defensive tactics were effective, but they had an enormous impact on the company going forward. They involved the expenditure of a lot of money. They changed the capital structure of the company radically. In the Unical case, they discriminated against a very substantial stockholder. That was the environment in which the poison pill was developed. And our argument was that, if you look at the world as it was, and not as Professor Jensen and Professor Bradley sort of imagined it to be, it was a dog-eat-dog situation, and the poison pill had two huge advantages over these things that I've just described. Number one, you adopted it in advance of any takeover activity. You didn't wait until the takeover proponent was at the door, and you had to sort of act in a big hurry with all the uncertainty which attends a highly emotional situation like one in which your company is going to be potentially taken over. So it's what we call a pre-planned defensive measure. And secondly, it didn't involve spending any money, changing your corporate structure, buying companies you didn't really want to buy, or selling assets you didn't really want to sell. It involved essentially issuing a piece of paper and then let's see what happens. We told that story through Higgins, through Trobe, through John Wilcox, and I have to say, like I think most good trials, the real art of a trial is telling a story and making the decision maker like your story. We told, I think, a very good story. Skadden, with all due respect to my good friends Mitchell and Shapiro and the rest of them, kind of came in with this very abstract argument, you just can't do this. And I don't think, therefore, that it's a coincidence that we won. I just think we were telling a story, and it was a true story, and it was a compelling story.
As they explained earlier, the lawyers from Skadden knew that the quality of Household's board of directors raised a formidable defense. In contrast, the plaintiff's witnesses didn't come off quite as strong.
These guys essentially gave themselves away. They were basically academics. I remember, for example, Jensen. I asked him, Professor Jensen, did you ever, actually represent some company that was faced with a He says, no, this was his answer. I don't spend my time, he says, I'm quoting him, poring over the entrails of actual transactions. I mean, I was ready to sit down right then and there. I must say honestly, I don't remember Bradley's testimony as well, but Jensen, well, it was an honest man, but he was a theoretician. Then there was Ace Greenberg, who, as I say, I would have to say he imploded on the witness. And I think even Skadden must have been embarrassed. I think the Chancellor's opinion describes his testimony as forceful or some such word, but believe me, it was a lot more than forceful. And then the last guy they put on was this fellow Clark Abbott from Morgan Stanley. And he was an honest man, and he basically agreed. Takeover activity, tender offers, especially these two-tier offers, are coercive. He actually testified, shareholders have no choice. Everybody tenders. The consequence was that when Skadden came to file its appeal brief, Clark Abbott vanished. He was not mentioned once in an 85-page brief. I should say he was very much mentioned in our brief.
Skadden's Mike Mitchell acknowledged that Ace Greenberg's testimony didn't help their case, despite his success on Wall Street.
And Greenberg did not come across as a good witness before Walsh. I remember Wachtel would refer to him as having a vested ideological opposition to any defensive steps taken by the directors. And that's what he was. He was a great, great trader, and he was our Wall Street witness. Why was he our Wall Street witness? Because we couldn't get anybody else to testify.
Still, the political environment in which the case arose may have had a lot to do with the success of Household's arguments and witnesses. As Skadden's lawyers explained it,
at the time, you had two movements going on. You had one movement of emphasizing the rights of shareholders. You had the emergence of Mike Milken and already availability of enormous amounts of money. You had people like Boone Pickens, Irwin Jacobs, willing to make offers for companies and then accept green mail to be taken out of their positions. You had academics like Michael Jensen at Harvard, Mike Bradley, Easterbrook, all saying that takeovers are good for the economy. But then on the other side, you had the business establishment saying, wait a minute, there are a lot of abuses to takeovers. You have companies selling off assets when they shouldn't be. You have employees losing their job because how are you going to take care of the debt that was incurred in a takeover? You had the Greenmail situations. You had Pac-Man, which was an absurd situation between Martin Marietta and Bendix. So, and you had Marty Lipton on their side. Now, I think at the time of trial, we were losing that battle, and it's reflected in the opinions. And this really surprised me. You look at the opinions; they talk about bust-up takeovers, talk about coercive acquisition techniques. They were just relishing the judges in this language, and that surprised me. I didn't expect that was going to happen. There was no sympathy on their side or the judge's side for the person who wanted to be free to make takeovers.
Which maybe shouldn't be surprising in retrospect. The other major political force is the unions. And the unions were all against this because their people lost their jobs. So you've got the business community and the labor community lobbying politicians. And then if you look at the people who were making the takeover proposals, they were not exactly the most attractive people in the world. They were wild men, a lot of them, and grandiose, and talked in very colorful terms and maybe lived very big, but they didn't seem to be people who were terribly concerned about the people whose businesses and jobs they would end up owning. And I've never felt that anything but the facts mattered and how they hit the decider, whether it was a jury or a judge. Who was the good person? Who was the evil person? Who do I like and who do I not like? And that tends to determine how the cases come out. And here you had both business and labor and the politicians against the position that we were taking. And you have a bunch of financial manipulators, to put it nicely, who can borrow a lot of money and they borrow by selling something called junk bonds, which doesn't sound very nice, to take over a company, sell off its parts, fire a lot of people. Not an attractive picture. I think we were naive not to recognize that there was really no constituency for these raiders being financed by junk bonds who are going to sell off things and cause people to lose their jobs. There just wasn't. And judges are susceptible to those atmospherics.
Simultaneous developments in the takeover world didn't help the challenger either, especially with its key argument that shareholder rights plans would totally stop unsolicited takeover bids. Because just before the household case was argued in the Delaware Supreme Court, a hostile bidder, Sir James Goldsmith, went ahead and bought over 20% of the stock of Crown Zellerback, even though that activated the company's rights plan and made the rights irredeemable.
It knocked the underpinnings from our argument that the rights were a sham and would never be exercised. Because in Crown Zellerback, which had the exact same pill as Household, Sir James, after giving 48 hours notice to Crown Zellerback, said, I'm going to buy over 20%, and you have until Monday at 5 o'clock. And they didn't pull the pill. They went before Judge Cannella. I argued against it. And I was in an anomalous situation. I knew a week from now, Irv Shapiro would be arguing in the Supreme Court that the pill was invalid because it would prevent takeovers. Well, and would never be exercised. Well, here I'm in court saying that Sir James Goldsmith should be allowed to go through the pill if that's what he wants to do. So Jimmy goes through the pill, and he owns more than 20% of the stock. And there's a wonderful quote. No one had anticipated someone like Sir James Goldsmith, because what he said was, When we got to 19%, I told them I was going to explode the pill and buy more shares. They didn't believe me. All along, they thought I was bluffing. And that's what he was, a risk taker. And
If you knew Jimmy Goldsmith, you would not think he was bluffing, but people didn't anticipate.
right.
I mean, he was a gambler.
Stu knew. Yeah, he was. His father cut him off when he was in the the 8th grade at some prep school in England. Cut him off from any money and support. So he went to the racetrack with some money and hit a 5-horse parlay, and that then secured his education for the next couple of years.
He was an amazing.
And
But
so what he did hurt us, I thought, more than it should have, but McNeely just jumped on it for two of our principal arguments.
Another outside influence was the appearance of the United States Securities and Exchange Commission in support of the plaintiff. But because the 5 commissioners were split 3-2 on the issue, the SEC's appearance may have actually helped Household and its directors.
The fact that the SEC itself divided in half, essentially, on this point, made our point. This was a matter of debate. Some people think it's a good idea. Some people think it's a bad idea. That's exactly the situation in which the business judgment rule is meant to operate, and specifically a situation in which the business judgment rule immunizes a board decision from judicial second-guessing. So a great theme of our appeal brief was, in a polite but cautionary way to the Supreme Court of Delaware, you fellows ought to stay out of this thing. This is a matter of contention and dispute. Some people are all in favor of takeovers, like Professor so-and-so and so-and-so, and some people think it's a bad idea. That's why God invented boards of directors. And the SEC brief, in a peculiar way, I think, strongly supported our position on that. And of course, that was the position the Delaware Supreme Court adopted.
Another outside development that supported the defense was the Delaware Supreme Court's decision in the Unical case, which came down just as the Household case was being argued in that court.
Unical obviously was not briefed by us because it hadn't been decided at the time that our brief was put in. But Unical obviously was a very helpful decision. That's the decision in which the Delaware Supreme Court held that the Unical Corporation, defending against an unwanted takeover attempt, a 2-tier bust-up takeover attempt by Boone Pickens, could do an exchange offer for its own shares and not buy Boone Pickens' shares. That was, to me, a perfect example of the kind of, I don't want to use the word radical, but potentially self-destructive defensive activity that I just listed a whole bunch of examples of a few minutes ago. I mean, here the company's going to spend a lot of money and change its capital structure and so on to defeat a takeover offer. Our feeling was, well, hell, if they can do that sort of thing, issuing a piece of paper with a right to redeem the piece of paper in favor of a fair offer should be a walk in the park. And I don't want to overstate our optimism as we approach the Delaware Supreme Court decision, but Unical was certainly an enormously helpful decision. And had it been decided before we filed our brief, you can bet we would have briefed it.
The chronological coincidence of the Unical and Household cases made life, well, interesting for Household's Delaware counsel Charlie Richards, who was also representing Mesa Petroleum, the hostile bidder for Unical.
In your argument in Household, there is a point at which you do reference Unical, and you mentioned to the court that you're not going to re-argue that case. The courtroom kind of burst into laughter, and then you mentioned, but I will be happy to re-argue it if you'd like. How did you, I mean, there's also a very famous cartoon, famous in my world, cartoon of you in a newspaper where you're holding the scales of justice and Household is on one side and Unical is on the other side. How did you, in your mind, distinguish those two cases? Because exactly, in one, you're representing Boone Pickens, who was perceived to be the raider, and, there was a defensive mechanism in place. On Household, obviously, we're representing the defendant who had imposed the defensive mechanism. How did you, in your mind, kind of square those two things?
Well, to me, they were separate, and it sort of came on the tradition that our firm and other firms had for a long time been representing both acquirers and acquirees, if you will, corporations, targets. So, in a way, that was a problem that our firm and other firms had already faced because we felt we could represent acquirers and could represent targets. And the devices, of course, were different. I mean, the rights plan was quite different than the discriminatory self-tender in Unical. But that question that you asked me did trouble my clients in the household, or at least the Wachtell-Lipton firm. And in fact, they asked me about it, and I told them I didn't think it would be a problem. But they said, well, I think we're going to come down and watch the watch the Unical argument, which went first. The Unical was argued on Wednesday and household the following Tuesday. So Mike Schwartz and I think maybe George Katz and about 10 of his colleagues came down and sat in the front row when I argued Unical. And
Not exactly cheering you on.
no, and it did create a sort of a pressure in the back of my mind as to whether or not if I'd said something in defense of Mesa and Unical's case, it would offend my clients in household. But it turned out it didn't, that they agreed with me that there really wasn't a conflict between the two positions.
Of course, Mr. Richards still had to navigate the competing views of his co-counsel about how to argue the case in the Delaware Supreme Court.
The Wachtell-Liptons, they wanted to know how my argument was going to go. So they came down a day before, and we had a practice session in our conference room, and I think there were about 15 of them there. And I knew from previous experience with them that as our firm, there would have been a different guy would have been responsible for a different section. And they were all sitting there. And so when I made my oral argument, I knew from previous experience that each one would want to make sure that I had included his point. Well, that really wasn't the best way to make an oral argument to the Delaware Supreme Court. First of all, they would never permit you to drone through your brief from front to back. And secondly, maybe 2/3 of the arguments really weren't important by the time you got to the Supreme Court. So as I think we discussed, the rehearsal didn't really go so well, and the
A lot of hurt feelings. You didn't really stress my part of the argument as much as you should have.
And so I'm going to be making the argument the next day, and I'm realizing the rehearsal didn't go very well, and they're telling me nicely they didn't think the rehearsal very well. And I said, well, that's really not what's going to happen. I'm going to go down there and I'm going to start, and the Supreme Court's going to start asking questions, and it'll be free-flowing, and it'll be based upon my knowledge of the case, not what I've written down as a prepared argument. And that's what happened.
Of course, with the benefit of hindsight, it was a good choice to have Charlie Richards make the Supreme Court argument. With the same hindsight, the choice of former DuPont CEO Irving Shapiro, Stewart's father, as the opposing advocate may not have worked out so well. On one hand, there were plausible strategic reasons to have Mr. Shapiro Sr. make the argument.
He also got the confidence of the people who ran DuPont. Obviously, he was one of the brightest men I've ever known. He came to us after DuPont as a partner. We all agreed that there was some feeling that the business community in the United States wanted this thing. Irv Shapiro was the business community. Right. He was the chairman or whatever of the Business Roundtable, and then he was the emeritus chairman of the Business Roundtable, which is the establishment thing. Sure. And I think it was felt by my partners that if Irv was arguing it, one couldn't really say that we were talking for the bust-up takeover people. because he'd been chairman of DuPont and all the rest of this stuff. He's on the board of IBM. He was on the board of Citibank. I mean, he was Mr. Establishment, and we thought that he carried that aura, and we thought that he'd make a very good argument, and he did.
On the other hand, lawyers on both sides came to think that choosing Irv Shapiro to make the Supreme Court argument might have backfired.
Irv was positioned to bring a lot of clout and panache, and
It didn't work. Well, no, I didn't, and I think I heard later that the Supreme Court itself was really puzzled by that.
I thought what Skadden did was also actually helpful for us. They had Irving Shapiro make the argument for them. And of course, he was the chairman of the DuPont Company, and what more important company in Delaware than the DuPont Company? And he had been chairman of the Business Roundtable. So, and he had been a trained litigator, but many years before, 20 or 30 years before. And so they were bringing him in to argue, and I sensed, but I can't point to anything I sensed that this would happen, and I sensed during the argument that it would happen, that while he was very careful not to talk down to the Supreme Court and to tell him really what the law ought to be from my point of view as chairman of the Business Roundtable, nevertheless, the whole implication of bringing Irving Shapiro in, rather than one of the senior skilled litigators from Skadden Arps or Rod Ward in, was, I think, attempting to bully the Supreme Court. And I don't think the Supreme Court in general bullies easily, and Drew Moore in particular would not. So I thought that, I don't think it had anything to do with the outcome of the case, but I thought that was something that maybe wasn't successful for them.
One of the Skadden lawyers who tried the case against me was a fellow named Stuart Shapiro, a good lawyer and a good friend. Stuart is the son of Irving Shapiro, who was for many years the chairman of DuPont, a major Delaware company, not only in the sense of incorporated in Delaware, but physically based in Delaware. And when the Chancery Court ruled as it did, Stuart told George Katz and me one day that the appeal was going to be argued for Moran, for the plaintiff, by Irving Shapiro. And clearly their hope was that having the chairman of DuPont, this major Delaware presence, would have some kind of extra influence with the Supreme Court of Delaware. I remember George said, "Gee, that's funny," he said to Stuart. "Our case is going to be argued by Bella Katz." Stuart said, "Who's Bella Katz?" "Well, your father is arguing the case for you. We're going to have my mother argue it for us." Anyway, we didn't have Bella Katz argue it. We had Charlie Richards argue it for us. We did feel that a Delaware lawyer rather than a New York, even though we had obviously carried the laboring oar at the trial, we did think that as a matter of etiquette before the Delaware Supreme Court, that a Delaware lawyer should argue it.
In the end, though, none of the strategic calls about what witnesses to present, which lawyers should make the argument, or what argument should be emphasized, really seemed to make the difference between winning and losing. On both sides, rather, the lawyers acknowledged that it was natural for the courts to accept the shareholder rights plan in the abstract, and leave for another day the question of whether a board of directors was using that device inequitably.
Did you think that plaintiffs really didn't have a ripe case?
Well, we certainly argued that. Nobody seemed to be really interested in the ripeness argument, and it really turned on the fact that, in a way, the court said it wasn't ripe, not technically on a ripeness argument, because it said, look, we can revisit this. If Household ever tries to utilize the pill against an acquirer, then we will look and see what their board of directors did and so forth. And so while ripeness as a legal concept, it wasn't effective, the underlying philosophical concept, I think, really won the day.
Because it came before the court in a sort of an abstract mode, And in fact, if you read both the Chancery Court opinion and the affirmance by the Delaware Supreme Court, both of those opinions say that plaintiffs' fears will have to await another day and it'll all sort out when an actual transaction's on the table and we see how the household board actually administers the pill. There was a flavor about the two decisions at both the trial level and the appellate level of essentially saying you fellas are in court too early. But they were just champing at the bit to declare this, to have this thing declared illegal.
We were being driven by our senior partner who was in this head-to-head battle with his very close friend but rival over this device. And, you know, and after, frankly, after the Unical decision came down, anybody who was not deeply enmeshed but could stand back could see that, you know, the Supreme Court had said, all right, you know, we'll reserve to ourselves, the courts, the ability to evaluate how directors use their powers. That doesn't mean we stop them from having powers. It just means that we get the chance to say whether they use them appropriately or not, which is a great place for judges to be in, right? Keeps them in the game.
I agree with Stu. I mean, when you go to the end of Walsh's opinion, you know, he talks about that the plan creates the potential for the misuse of directorial authority. And then he says, through its power to redeem the rights before a triggering event occurs, the household board has assumed a plenary negotiating role. It has also taken upon himself the responsibility for assuring the rights are not triggered in such a fashion as to inflict harm upon the corporation by rendering it acquisition-proof. It cannot be assumed that the board will act contrary to the interests of the shareholders. Those events and plaintiffs' fears must await another day. On the evidence presented, the adoption of the rights plan is an appropriate exercise of managerial judgment under the business judgment rule. And no matter what, as Stu says, had been presented to him, he would have found the same thing as he found right there. I'm not going to rule ahead of time they're going to misuse their authority. We'll wait and see what happens.
With the shareholder rights plan suddenly an accepted part of the corporate landscape, reactions were quick and predictable.
Our firm has always been run by corporate guys. And, you know, Peter Atkins, Roger Aaron, Finn Fogg, Morris Kramer, these are names known to every corporate merger and acquisitions person. And they had a whole lot of backed up poison pills to put in if we lost. And when we lost, wow, they just went in, you know, like that. And obviously that was a piece of business for them.
You hit the road and you go do your road show and do your poison pill presentation to as many boards as you can get to do it, right?
Yes. I mean, I never did that kind of thing, but that's probably it. Yeah.
That's what they did.
Yeah. But sure, no, I don't know whether they were hoping we'd lose or not, but they didn't dare. but they didn't dare tell Joe that, and he was really rocked by it. He thought this was really wrong.
So Mr. Flom was upset by the outcome.
He was. Well, he never told me he was upset with me, and actually one of the reasons we were delighted to have Mike Mitchell along is because he was very close to Joe and could explain what went on better than. I mean, Joe Flom dominated the law firm.
Of course. Yeah.
Just like Marty dominated Wachtell Lipton.
Yeah.
But, in contrast to Joe Flom, Marty Lipton was of course delighted with the outcome of the household case.
And as it happens, the morning the Delaware Supreme Court came down with its decision, Marty and I were at a board meeting together. It was a board meeting of Allied Signal. I guess we represented Allied and Skadden represented Signal. We were all at this board meeting together. And I remember Marty, so we heard that the that the jury had come in against Texaco for $10 billion. And then we heard that the Delaware Supreme Court had affirmed household. And Marty said to me, can you imagine, he said, if on the same morning this $10 billion verdict had happened and we had lost household? I mean, it was a fraught situation. There's no doubt about that. So that one, even then, even though we had Unical on our side and the rest of it, it was not a sure thing. Interestingly, at that board meeting of Allied Signal, Joe Flom was also present because he represented, I think it was the meeting at which Allied and Signal merged. And he represented Allied, we represented Signal. So Joe came over to Marty and me and shook our hands. Congratulations, you guys won the household case. And he said, and now he says, I'm going to issue some pills that'll make your toes curl. And they did. Of course, thereafter,
Everyone did.
You know, yesterday's news was that this pill was illegal, immoral, and fattening. Now, as far as they were concerned, it was a legitimate part of the arsenal, and they would deploy it as well as we.
And of course, the day after the Supreme Court, Skadden came out with this flip-in pill.
Yeah.
It was no longer going to be flip-over that Goldsmith was able to take advantage of because he delayed the merger till later on. The bad consequences would take place immediately once you went over 19.9%. I remember Peter Atkins, the chair of our litigation, our corporate department, had that ready to go, and they were traveling around the country, all the corporate guys, sticking that pill in.
So has the proliferation of the shareholder rights plan, or poison pill, been a good thing or a bad thing? It would take decades of experience and litigation to shape the answer to that question. But the architects and combatants who shaped and contested the household rights plan had remarkably uniform assessments.
The genius of Lipton's pill was this was a defense that made people stop. It was an absolute defense, but it didn't inflict any harm on the company. It didn't inflict any permanent change. And the court could be, the company could be put in a position where the directors would be compelled to redeem the pill.
I think that the decision was correct in terms of validating the pill as a device that they could create to give themselves the power to deal with a hostile takeover. So I think on a policy basis, the notion that the directors have some additional power to negotiate is a perfectly sensible one.
I essentially agree with Stu. There was no reason in the abstract to take away this power that the pill gave the board to negotiate with a potential acquirer. There were abuses that were going on. There were these people who were taking green mail. There were these asset sales at low prices. There was this ridiculous Pac-Man situation. And by saying we'll await a specific case, I think Walsh was right.
The poison pill in the M&A context, a good thing or a bad thing?
I thought it was a good thing. Well, I don't want to bore you with stories, but I think it was a good thing, and I think the reason why it was a good thing, it was the only thing that really put a damper on a period of time in which junk bond financing and the overall market made companies vulnerable to being busted up, taken over. It was a period that I thought threatened the economy of the country.
Well, Peter, back 30 years ago when the poison pill really seemed to be something people thought was worth fighting about, your firm was, at least initially, on the other side, and I've seen interviews of some of your partners who stoutly maintain that the pill should have been invalidated from inception and never allowed to go forward, whether it's relevant or not now or not. But where do you stand looking back on it now? A good thing, bad thing, or maybe irrelevant?
Well, you know, with apologies to my partners, whoever they were who thought that. I mean, I actually think it's a mechanism that is very consistent with what Delaware law was, and certainly the realities of that period. I mean, I think Marty's right that there was no other tool available.
And Art, I always thought of you and your firm as sort of a neutral,
I
an
have a
agnostic.
medium.
Yeah.
I would say it's the single most important development in the takeover field, and served the basic functions that it was designed to, one, increasing the negotiating power of a target board, preventing the taking of control in the marketplace. I mean, when you think about it, it is truly an extraordinary invention that still has vitality and will continue to have vitality.
Household, the company, also continued to have vitality, at least for a while, after its successful defense of its shareholder rights plan. But the merger and acquisition market also continued to have vitality. And in 2003, Household was sold to HSBC for about $14 billion. The poison pill was evidently not an impediment to that deal.